Welcome to Rise from the Ashes, the podcast channel website that focuses on legal matters that may affect you and your family. On the program, we'll be talking with attorneys, mediators, counselors, and other family law professionals who understand the need to assist families and individuals in resolving the personal and legal issues they may be facing. Rise from the Ashes is sponsored by Mundahl Law, who specializes in assisting families and individuals through the legal process with respect, dignity, and caring. Mundahl Law is dedicated to helping people to solve their legal problems. You can visit the Mundahl Law website at mundahllaw.com or call to schedule a consultation with one of their qualified family law attorneys. Please keep in mind that this podcast is intended only to inform and to assist in understanding legal and personal issues as they relate to family law. It should never be considered as a replacement for a qualified family law attorney. When in doubt, please contact a professional. Rise from the Ashes, focusing on matters of the family because family matters. Hello and welcome to our podcast, Rise from the Ashes. I'm David Braddock, and I'll be your host for the program. We're speaking this time with Susan Mundahl, an attorney with Mundahl Law, who has about 28 years of experience as primarily family law attorney. Isn't that right, Susan?
That's right.
Now, this is a topic that seems like you probably have a bit of experience with, mediation.
Oh, yes. I've handled hundreds of divorces and custody and parenting time matters, and in most cases, we're required by law to engage in some form of alternative dispute resolution we call ADR, and the most popular form is mediation.
Okay. And just to make sure that we're all on the same page, and of course with all of our listeners, perhaps you could tell us, what exactly is mediation for a divorce, and what does it entail?
Well, mediation is, as I said, a form of alternative dispute resolution. And that means that instead of going to trial and having the matter heard by a judge, the parties attempt to negotiate a settlement on their own. We recognize that parties are happier when they reach the agreements, and they're more likely to follow through with what they've agreed to than if they have been court-ordered to do something.
So essentially, the parties go someplace else other than their attorney's place of business. Is that correct? Or?
That's right. Mediation takes place with a qualified, impartial, or neutral person. And so there's a number of people who are on a list. It's called a Rule 114 list with the Minnesota Supreme Court. They're qualified mediators. They've been trained to assist people in reaching these agreements.
To make sure that both sides are considered equally, I take it.
That's right. I think it is really important that both sides need to be heard. Usually what happens, the reason people are getting a divorce is there's a breakdown in communication. And so neither side is listening to the other. This is an opportunity to get with this neutral third party to be able to talk about the issues that need to be resolved as a part of their divorce. And those issues include property distribution, child support, custody and parenting time, taxes, retirement, spousal support. Those are just a few of the issues that can all be resolved with a good mediator.
It sounds like the key is definitely what you just said. A good mediator will really help this process.
That's correct. In fact, we have a new system, actually, where we're now starting to do evaluative mediation, which I think is an even better hybrid of regular mediation. That is because now this impartial third party is not just someone that doesn't know something about the law or about divorces, but they're actually people who have a great deal of experience in family law, either as financial experts or as experienced family law attorneys. And what they are allowed to do then is give you their opinion on how they see that your case might be handled. It provides what I call the voice of reason for parties.
All right, let's say that someone listening is involved in a divorce and it looks like there may need to be some form of mediation. Is there anything that they can do to properly get ready for that mediation?
Yes. I think the first thing that's important is a person needs to have the right spirit in going into it, that they want to reach a compromise. They need to understand what are the issues at stake and the impact of their taking a position on those, on what's at stake. For instance, think very carefully. If you believe that you need 50% parenting time, is that a realistic position? You need to be thinking about those things, items that you consider non-negotiable and what is negotiable. And hopefully the majority of what you're going to do is think about ways to negotiate. If you think that something only has 2 ways to be resolved, think again. There usually are 3 or 4 different ways that it could be resolved. And your willingness to listen to the other side in mediation and to find out why something is important is going to help you a long way in reaching an agreement in mediation.
So in those early stages, is it helpful to get your attorney involved in some of that process to make those determinations?
Absolutely. This is an important reason that you get an experienced family law attorney to assist you. You should have at least one meeting with your attorney before any mediation. And let's say you're talking about custody and parenting time. Your attorney can tell you what legal custody means, what physical custody means, and what the ramifications are for your case. They can even talk to you about parenting plans and the fact that you don't need to have a custody designation in some cases. An attorney can assist you in talking about what is going to be a reasonable parenting plan, and you're going to tell your attorney what your hours that each of you work. And those kind of things can all be helpful to have in mind prior to the mediation. You'll want to tell your attorney what items you believe are negotiable and what aren't.
All right, well, that should take care of distinguishing the non-negotiables. What about the items that a divorced client may be willing to negotiate?
Oh, I think that's an excellent place to start, actually. Think about the number of things that can be done in order to facilitate a better parenting plan. Or if we are talking about property settlement, those are all very important to have in mind. And then I suggest, too, if you're talking about property issues, you should have a spreadsheet on what the assets and liabilities are and what you believe the values of them to be. That's going to go a long way in helping you identify how the property settlement should be structured. If you're talking about custody and parenting time, think in terms of what should the everyday schedule be? What should the summer schedule be if different? What should the holiday schedule be? What should the vacation schedule be? What should communication look like, and what should transportation look like? If you take those into consideration and have a good idea in your mind, and then open your mind to listen to how the other side views those same categories, then you can reach a very effective mediated agreement.
Is child support typically discussed in mediation process?
Well, unfortunately, most child support is like the hidden issue in any custody and parenting time matter, and it really shouldn't be. It should be that if what you're really talking about is you want 50-50 parenting time because you want a lower child support amount. One, that's wrong thinking, because custody and parenting time is really looking out for what's in the best interest of your children, and child support is simply a result of that. The bottom line is both parents should recognize that child support is an important aspect. Children need to be supported throughout their childhood, and in this state we recognize that both parents have an obligation to support their children. So it should be a secondary issue to custody and parenting time, but it is certainly important in the financial section.
Now, once we get into the mediation process, does the mediator allow for the two sides to express their opinions as they go about the things that they're being asked to decide upon?
Oh, absolutely. And I think the important thing there to remember is to be courteous and also to leave your anger outside the door. We understand that you are all going through the grief cycle. You are going everywhere from anger to depression to bargaining and hopefully to acceptance, and that your partner is doing the same thing, but they may be doing it at a different rate. But no mediation will be successful if both people are in anger and blaming. Then mediation can have no place in that because there is no willingness to listen to the other side. And that is a key to mediation, is both parties listening to what the other side needs and wants, and then negotiating a reasonable settlement.
So even though there's the elements of a grieving process, It sounds like you're saying because they're having to let go of the family lifestyle as it's currently structured and letting go of their spouse and perhaps whatever the elements of the children and the parenting time and so forth. But that doesn't necessarily make it like therapy.
Well, I agree with you. This is not therapy. In fact, my recommendation is that if you're sitting in anger or depression or any of those things that are not helpful to the mediation process, that you seek out a good therapist. There's group counseling sessions or personal coaches, anyone that can help you deal with your feelings of anger and resentment. We understand that in a divorce, people feel betrayed and that they need to work through that. That is not what mediation is about. Mediation is for people who are ready to move forward with their life. They're ready to negotiate a reasonable settlement with the other side, and they don't want to go to trial. A lot of people don't realize that the most important piece about mediation is that it, number one, it allows you to make decisions about your family, the two of you. The two of you are the most important people in making that decision. Second, it saves a lot of time and money. Trials are very expensive, and they take a long time to get to trial. And in fact, I've had it where we had trial one day, and then we didn't finish, and so we had to do a second day, and the court set the second day 3 months later. And so you have the principle of justice delayed is justice denied. So it doesn't make sense to use the legal system for going to trial to prove that you're right. You're much better off getting past that and just negotiate a reasonable settlement where both of you have to give something.
Is there anything in particular that should be kept in mind when looking at mediation for a divorce?
I think the most important thing to keep in mind is to look for a good mediator, one who is very familiar with family law and legal principles, but understand a mediator is not giving legal advice to the parties. So it is important to have a good family law attorney representing your interest and one that you can speak with so you know your rights going into it and also know what your areas for negotiation are going to be. Then the most important part about the mediation is listen to the other side. Understand why things are important to the other side. This isn't just about getting your way. This actually is where both parties have to be willing to give. I hear in so many mediations, someone said, we're giving everything and they're giving nothing. And as long as you have that sense that you're trying to prove and it's point here and a point there, you're going to have a very difficult time in being able to reach an agreement. If you can put aside that idea that I have to be right, then I think you can just think of a solution that's going to be best for your children and yourselves.
And avoid a lengthy trial process.
Absolutely. That is the main reason the courts insist on alternative dispute resolution. Just remember, folks, judges don't like you. And I say that in all honesty. I have never heard a judge say, oh, goody, I have divorce court today. They hate you. They do not want to hear about all of your issues. They do not want to make decisions about your family. And when a judge says, I tried to give something to each of them, what that means is both of you are going to get screwed a little, and understand that. So go to mediation, go with an expectation of trying to do the very best you can to put your emotions aside and to reach a good settlement that's good for your children and good for yourselves. And it's not going to be something you necessarily like, but ask yourself, can I live with it? The important key to a good mediation can sometimes be getting helpful legal advice from an experienced family law attorney.
Well, thank you so much, Susan, for joining us today and for all this helpful information regarding successful divorce mediation.
Thank you, David.
You are listening to Rise from the Ashes, the podcast channel that takes a careful look at all things having to do with legal procedure within the family law process. Rise from the Ashes is sponsored by Mundahl Law, who specializes in assisting families and individuals through the legal process with respect, dignity, and caring. Mundahl Law is dedicated to helping people to solve their legal problems. You can visit the Mundahl Law website at mundahllaw.com or call to schedule a consultation with one of their qualified family law attorneys. Rise from the ashes, focusing on matters of the family, because family matters.